I mentioned this position about paper title, and this is something that's frequently overlooked by transactional property lawyers and indeed litigators. You can't claim adverse possession against a dissolved overseas company or a dissolved British company where the title has been disclaimed, nor can you claim it against an individual that lacks capacity. So I'm dealing with a matter at the moment where an old lady is suffering from dementia and she's in hospital. And in those circumstances, the clock does not tick and the clock stops when that person doesn't have capacity. Then it will only begin to tick again when capacity is resumed, if it's ever resumed. So it's always important when you're looking at bringing a claim for adverse possession to see what the status of the paper title owner is. And when you are attempting or advising someone in connection with the opposition of an adverse possession claim, it's again important to ascertain your client's capacity. I've got a matter on the go at the moment where there are joint owners of a property, one of whom is suffering from dementia. And the issue there is, does the clock stop ticking? And counsel's attitude is, no, it doesn't. I can't find any law on the point, to be honest with you. The sort of devil in me says, well, if you're a joint owner of a property, then if you lack capacity, then you're not able to defend an adverse possession claim, and therefore surely the clock should stop ticking. Unfortunately, I don't think my client's got the appetite to take that to court to see what the position is, but it's an interesting one. If someone lacks capacity, if a company owns land and it's dissolved, then the clock does not tick. Further, if you make a determined boundary application to the land registry in connection with neighbour encroachment, that determined boundary application will also stop the clock ticking. The problem with a determined boundary application, however, is that if you make it and the neighbour objects to it, then the matter will be referred to tribunal, and all that I said about evidence and costs a little earlier will apply. We mentioned factual possession, and I want to drill down a little more as to what I mean by this. Although it's not necessary to fence off land, it is necessary for there to be an appropriate degree of physical control. So fencing off land is useful. Fencing off land and putting gates in it so that neighbours and visitors can enter onto the land is far from helpful. Providing evidence of tending to grass or plants or shrubs, providing evidence of asking people to get off the land, signage, etc., will be useful. Evidence as to the amount of attendance on site is going to be particularly useful. There must be single and exclusive possession. So if you share land with the paper title owner, or indeed anyone else, then you can't claim adverse possession. And although you're not required to treat the land as your own, you are required to deal with the land as an occupying owner. So there's, in essence, it's a play on words, isn't it? It's one and the same thing. And this point about unequivocal use is so important. If you have an easement, if you have some form of other entitlement to use or occupy the land, that immediately stymies your adverse possession claim.